What it means when a will is contested, it means that somebody doesn't agree with that will and they're trying to fight it. And they're basically saying, no, we ain't doing that. And it can be for a lot of different reasons. Like the testator did not have capacity, meaning like they're in a hospital bed and, they just signed a document because you put it in front of them. They didn't know what it was. And, all of a sudden, instead of the kids getting it, the maid who's been taking care of them is now getting all the money and things. And it's basically somebody's trying to say, no, that's not valid. Or there's multiple wills that come in and they're saying, no, my will's good. No, my will's good. Take my will because my will benefits me. And now take my will because my will benefits me. It means that if you're contesting it, it means you're disagreeing with it and you're trying to convince the court to not follow it. If that's happening, you've got to get the best probate attorney that you can find. Somebody that's going to know the law and be able to go in and fight for you if necessary, but also try and get you a settlement out of the deal. Any number of different things, but you need somebody who's a good negotiator and a good litigator. So when someone dies, a lot of times people owe other people money. Sometimes they don't owe people money, but other people come in and claim that they did. So those are all called creditor claims. After someone dies, they have a certain amount of time with which to present their creditor claims. And as part of the probate process, you have to notify the known creditors, and you also have to post a notification about it so that unknown creditors, they basically have a limited amount of time to come in and say, no, I'm supposed to be paid something from the estate. And then when if they don't reply and they've been notified, their claim, they don't get to collect any money against the estate. But if they do reply, then you have to work and settle their claim. And sometimes you pay it full out, and sometimes you negotiate a settlement. It just depends on the facts and circumstances of the estate. Depends on how good the attorney is at being able to do that stuff. And it's part of the process. And after all the creditor claims are settled out, then the heirs can get distributed the remainder, assuming that there's money left in the estate after that. Sometimes the creditor claims eat all of it. If the creditor claims are going to eat all of it, then your attorney's skill is that much more important, because what you want to do is say, to settle it, and maybe they'll reduce it so that the heirs can get a little something, or sometimes a substantial amount. It just depends on what the circumstances and situation are. So you need to get a good attorney for that, but the creditors are dealt with as part of it. And the biggest creditor, the 800-pound gorilla in the room that will tear everyone's head off, is the IRS. You got to make sure that the IRS is paid because the government gets its money. Disagreements among heirs, they get resolved one or two different ways, either by having a full and final trial where the court makes the decision, which, by the way, is a lot of times like an all or nothing, or, like it's a bad Vegas gamble, or what the vast majority of the time we either negotiate or go to a mediation, and even at mediation we negotiate and we get to a settlement. It's called a family settlement agreement, and that settlement agreement determines who's going to get what, how everything's going to work out, and then we submit that to the court to approve it, and then it gets administered and executed to where it's distributed pursuant to that agreement. But the vast majority of the time, it's by agreement, so you need a good litigator and a good negotiator in order to get that done. Difference between mediation and litigation is that mediation is a step in the litigation process. Almost every court requires that you go to mediation prior to being able to go to a final trial. And what mediation is essentially a negotiation where you and your attorney are in one room, the other side and their attorney are in another room, and another attorney called a mediator goes back and forth between the rooms and tries to get a deal done. And if you get a deal done in a probate, you do that in what's called a family settlement agreement, and that lists out who's going to get what, how everything's going to play out. And so mediation is a step of that hopefully you get a settlement and end the litigation. And if not, then you go to a full and final trial and the judge decides. So if you've had a loved one die and you need to go through the probate process to protect your business, your inheritance, your children, or the children of the deceased, then go to Smooth Probate. We'll help you get through the probate process in the smoothest way, because probate doesn't have to be so hard.